Good afternoon, ma'am. This is my oral recitation, Article 11 to 15. Justifying circumstances and circumstances which exempt from criminal liability. Article 11. Justifying circumstances, the following do not occur on any criminal liability. Number 1 is any who acts in defense on his person or right provided that the following circumstance concur. First is unlawful aggression. Second is reasonable necessity of the means employed to prevent or repel it. The third is lack of sufficient provocation on the part of the person defending himself. Number 2 is any who acts in defense of the person or right of the spouse, ascendants, descendants, or legitimate, natural, or adopt, brothers or sister, or in his relatives, by affinity in the same degrees, and those or consanguinity within the fourth civil degree, provide that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisites in case the provocation was given by the person attacked, that the one making defense had no part therein. Anyone who acts in defense of the person or rights of a stranger provides that the first and second requisites mentioned in the first circumstance of his article are present, and that the person defending be not induced by revenge, resentment, or other evil motive. Any person who is ordered to avoid an evil or injury thus which cause damage of another provide that the following requisites are present. First, that is evil sought to be avoided actually exists. The second is that the injury fur be greater than that done avoided. The third is that there is no other practical and less harmful means of preventing it. Any person who acts in the fulfillment or duty or in the lawful exercise or a right or office. Number 6, any person who acts in obedience to an order issued by a superior some purpose. Article 12. Circumstances which exempt from criminal liability. The following are exempt from criminal liability. Number 1 is an imbecile for insane person unless later as during a lossy interval. When the imbecile on the insane person has committed and which the law defines is a felony, delito, the court shall order of the confinement in one of the hospitals or asylums established for a person the afflicted, which he shall not permitted to live without first obtaining the permission of the same court. Number 2 is a person under 9 years of age. A person over 9 years of age and under 15 unless he has acted with discernment, which is case such minor shall be proceeded against in accordance with the provisions of Article 80 of this code. When such minor is judgment adjudged to the criminality irresponsible, the court in conformity with the paragraph shall commit him to the care and custody of this family, who shall be charged with his surveillance and education. Otherwise, he shall be committed of the care of some institution or person mentioned in said Article 80. Number 4, any person who, while performing a lawful act with due care, cause an injury, mere accident without full intention of causing it. Any person who acts under the compulsion of the irresistible force. Number 6, any person who acts under the impulse of the uncontrollable fear, equal or greater injury. Any person who fails to perform and requires law in preventing by some unlawful and inspirable cause. Chapter 3 is circumstance which mitigates criminal liability. Article 13, mitigating circumstance. The following are mitigating circumstance. Those mentioned in the preceding chapter, when all requisites necessary to justice the act of exempting original liability in the respective case are not attendance. Number 2 is that offender is under 18 years of age, over 17 years. Case of minor, he shall be proceed against accordance with provision of Article 80. 3. That this offender had intention to commit so grave wrong as the committed. The sufficient provocation threat on the part of the offender party immediately proceed the acts is committed in the immediate mitigation of the grave offense to the one committing the felony, due to his proposed descendant, legitimate, natural, or adopted brother, sister, and relatives by affinity within the same degrees, that the have and upon impulse of powerful natural produce passion of imbuscation, that the offender had voluntarily surrendered himself to an person, authority, or agent that had voluntary case as the guilt before presentation of the evidence of the prosecution, that the offender there damp with suffering physical defect in the defense communication with her fellow beings. Number 9, such illness of the offender would diminish the exercise of the will power of the offense without however offense depriving him consciousness of his acts. And the number 10 is, and finally another circumstance of similar nature and analogous to those above mentioned. Chapter 14. Chapter 4, circumstance with aggravate criminal liability. Article 14, aggravating circumstance. The following are aggravating circumstances. Number 1 is that advantage be taken offenders of his public position. The number 2 is that the crime be committed concept or insult the public authorities. And then number 3 is the act committed by with insult or the disregard of respect due to the offense party of the scored of the rank of age 6 that he committed in the dwelling of the offender party in later of the given provocation. Number 4 is that is committed with abuse, confident of ungratefulness. Number 5 is that the crime committed and violation of chief executive of the Hesse presence of their were public authorities and engaged in the discharge of the police indicated worship. Number 6, that the crime committed in the nighttime on uninhabit or place or by the band whenever the circumstance which facilities the commission offense whenever more than 3 shall have acted together in commission of offense and shall deemed to be been committed by a band that the crime committed and said arm one person who insure of afforded impurity. That as accused is recidivist. Recidivist is one of at the time of trial for the crime shall have been previous convicted judgment as another crime embrace is same of the code. The offender has been prevented punished of the offense which law attach equal greater than for the more crime to which the lighter penalty that the criminal be committed and consider of the price reward of the promise that the crime committed by the means in addition fire poison explosions studying visual intentional damage therein retail of other sacrifice involving greater waste and ruin that the act committed with evidence number 14 that court pro disguise be employed. Number 15 is the advantage be taken support strength of the means of the employee to weaken the defense that the committed with treachery. There is treachery when offender committed the crimes against and the person who employ means methods form of the execution therefore of the directly and especially to ensure the execution with himself arising from defense of the offense part might mix. That means in employee circumstance brought about which ignominy to natural effects of acts that the crimes committed after the unlawful entry. There is unlawful entry when an entrance is affected by the not intended for the purpose. Number 19, that as means to the commission of the wall, floor of the windows to broken, that the crimes be committed with person under 15 years of age means of the mentor. Vehicle airships or similar rings that the warning done in the commission of the crimes deliberately augmented if the cause of necessary for the commission. Chapter 5 Alternative Circumstance, Article 15. Their concept alternative circumstance are there which must be taken to the consideration of aggravation, mitigating accordance to the nature of the crime and the other conditions attending the commission. They are relationship, intoxication, and degree for the education of the offender, and alternative circumstance relation shall be taken into consideration when the offender party is the accused ascendant, descendant, legitimate, natural, or adopted brothers or sister or relatives. By affinity, the degree of the offenders. The intoxication of the offender shall to be taken consideration of the integration circumstance which offender that is committing felony in a state intoxication and the same not habitual subsequent plan commit felony but their intoxication habitual intent shall be considered an aggravating circumstances. Thank you, ma'am. That's all. Thank you.